Hello, my name is Emily, and I am here today with nationally recognized authority and trust clause litigation, Dan Dalton. How are you today, Dan?
I am doing great, Emily. How are you?
I'm doing well, thank you. So, Dan, what are three things a local church should consider when thinking about litigating the trust clause?
Well, the very first thing is that you can challenge the trust clause. The United States Supreme Court decided in a case called Jones versus Wolf in 1979 that civil courts or secular courts um, have that ability in that they have it's called subject matter jurisdiction to hear a challenge to a trust clause. So you can litigate that trust clause enforceability, and so you can challenge that. The second thing is that your state law is going to control your case. So in some states, courts have made a decision that the trust clause is enforceable, and in other states, they have made decisions that it's not enforceable. But even when you have situations where states that have made a decision that it's not enforceable, you can look to other angles within state law and see, is there another way out? For example, we just did a jury trial in Florida for Bayshore Christian School that was located on the property of a former Methodist church. And there, what we used is a theory of prescriptive easement to allow the school to maintain and stay on those church properties. So that's one example. There's other examples where the church is not incorporated, and so the corporation code didn't apply, and the state law that talked about the trust clause didn't apply because it was not an incorporated entity. It's things like that that you just need to look specifically at your church to see how that works. So the second thing is looking at your state law. And the third thing is really to review your governing documents and your property deeds. So look at your articles of incorporation, and if you have the bylaws, look at your deeds and see exactly what they say. If there's no reference to the trust clause in the articles or in the deeds, that may help you on your way out. And again, this is going to be state specific, as we just talked about on that second element, but your governing documents may help you. And if you do have the trust clause in your articles or in your bylaws or in your deeds, there's ways to amend that or to revoke the trust, and we can look at that as well. So though there is a process and there is a method to kind of look through these matters in each state and in each case to see, is this enforceable or not? So the bottom line is yes, there is a path out. That path may not be straight up and to the left, or up and to the right, but it's going to be a situation where we are able to either challenge the trust clause in state court or to look to another method to preserve your property, both your real property, your personal property. And that's what I would just encourage you to work with us to figure out that best way forward.
Thank you for your insight, Dan. If your church is interested in hiring our firm, please reach out to our office at 313-859-6000 or email us today. Thank you.